Whitsunday.
Thank you, Mr Acting Speaker. I too would like to contribute to the cognate bill. I would like to put on the record, though, that 3 3/4 hours of debate for two significant bills, pieces of legislation, as well as amendments that have been circulated by the Attorney, is not adequate and flies in the face of what this parliament is set up to do, which is a robust debate and a way in which that we should have time to carefully consider legislation, make those representation from stakeholders and the communities in which we represent. I do want to place on the record, in particular, the respect at work and Kate Jenkins' work in this space, particularly in relation to sexual harassment as a real issue that continues in workplaces all across our state and nation, and the important role that a safe, inclusive and respectful workplace should have. I will leave any further comments, though, as outlined by our Shadow Attorney General in regards to the LNP's position on this bill and the way in which it's been cognated. I'll move on, though, to an area in my portfolio as the opposition spokesperson in relation to the Criminal Justice Legislation, Sexual Violence and Other Matters Amendment Bill of 2024, and that the bill aims to improve the justice system response to domestic and family and sexual violence as a result of the recommendations made by the Women's Safety and Justice Task Force, and we thank them for their work and their advocacy for women in particular, victim survivors of sexual violence, which this aims to also address. The existing offence of repeat sexual conduct with a child will now include adults in positions of care or authority or supervision who engage in unlawful sexual behaviour with children aged 16 or 17 years. And we note the amendments in regards to the position of authority offences in regards to health practitioners, but also in the residential care service, where a person associated with a residential care service that provides accommodation where the child resides, and the further clarity around those definitions, which is very critical for safeguards, given that we have almost 2,000 children in residential care services in this state, an unprecedented number. Amendments regarding the new provisions concerning tendency evidence and coincidence evidence by ensuring that they align now with interstate laws, and that these changes have been advocated by many, those with lived experience of their horrendous court experiences, in particular victim survivors of sexual violence, that when they are in a courtroom reliving their traumatic and violent experiences, that hopefully these amendments go a long way. This will allow for expert evidence to be given in criminal sexual offence trials to dispel what has historically been myths about the experience of a rape victim, about their expected behaviour at the time of a criminal act or post the criminal act, which many, particularly women, have endured for many, many decades. However, Mr Deputy Speaker, what is a sad indictment on this government is that currently there are some 420 victims in Queensland, as reported by The Australian in the media over the past 24 hours, who have waited more than 12 months for the result of their rape kits, a current backlog in current cases of 20 times larger than Victoria. Results that victims of sexual assault are awaiting to see if there is DNA evidence present, which is critical in the prosecution of any case. And today, Mr Deputy Speaker, the announcement by the LNP, if elected in October, by Dr Kirsty Wright to oversee the DNA lab reform, which goes to the heart of justice for
Point of order,
sexual...
Pause the clock. Attorney General, what's your point of order?
I appreciate the member's comments are important issues, but they're not relevant to the bill, and I ask the member to be brought back to the bill.
Attorney General, I'm listening closely to the member's contribution, and I'm finding it relevant for the minute, but I'll ask the member to speak to the long title of the bill. Thank you.
Thank you, Mr Deputy Speaker. Criminal justice legislation, sexual violence. We're talking about evidence, we're talking about amendments, and I think DNA evidence, Mr Deputy Speaker, is critical when we're talking about what reform is there. And the government doesn't get to cherry pick what they want to own and what they want to disregard, Mr Deputy Speaker. Yeah. This goes to the heart of victim survivors. This goes to the heart of the opportunity for members in this House to raise critical issues that go to the heart of our justice system, which this government is failing.
Pause the clock.
Deputy
Member
Speaker,
for Green Slopes, what's your point of order?
it may go to the heart of many things, but it doesn't make it relevant to the current debate, and I would argue that this is not relevant to the debate.
Member for Green Slopes, resume your seat. Member for Green Slope, I've been listening closely to the member and I've taken some advice and I'm finding that the member is being relevant to the bill. Member for Whitsunday, you have a call.
Thank you, Mr Deputy Speaker. And once again, those opposite forming a protection racket to stifle victim survivors' voice in this House, Mr Deputy Speaker, and it is shameful and it is disgraceful. Mr Deputy Speaker, I'd like to move on, if it's okay with government members, then to speak about victim survivors of strangulation, Mr Deputy Speaker, given, and I point to the amendments being outlined also by the attorney. After the long-term advocacy, Mr Deputy Speaker, in particular, and I want to pay tribute to Betty Taylor from the Red Rose Foundation and now her incoming CEO, Brian Sullivan. And the attorney pointed out that these amendments have come about on the basis of a Court of Appeal, but also of stakeholder advocacy, Mr Deputy Speaker, and in particular around the amendment and definition of choking, suffocation or strangulation in a domestic setting for subsection 1. And, Mr Deputy Speaker, can I say this has been called upon for years and years. And in the final days of this Labor government, finally, they have listened. But it is the victims and it is the Red Rose Foundation that own this amendment. And I hope it goes a long way, Mr Deputy Speaker, to ensuring those victim survivors get justice. And I want to highlight, Mr Deputy Speaker, the prevalence that we are seeing in regards to the strangulation offences and the unintended consequences that have occurred under this government's watch by not clearly defining strangulation, Mr Deputy Speaker. Across this state, in particular, the strangulation offences lodged in the Magistrates Court here in Brisbane have been up in the last 12 months, an increase. And what we've seen is defendants convicted of strangulation offences not at the thresholds and the numbers that victim survivors expect. And, Mr Deputy Speaker, when we see offences lodged in the last 12 months across the state of 1,186 and only those with penalties imposed of 423, there was clearly a failing in the legislation because of the lack of clarity around choking, suffocation and strangulation in a domestic setting. Why is this important, Mr Deputy Speaker? Because the prevalence of this with in particular, that was highlighted by the Women's Safety and Justice Task Force, is critical that this amendment be made, and I certainly watch with anticipation how this plays out in further cases across the courts, Mr Deputy Speaker. Once again, I outline not enough time, Mr Deputy Speaker, not enough consultation, rushing bills through without giving members of this House adequate opportunity to be able to express in full what are two very complex bills, Mr Deputy Speaker, and let alone in my time being shut down by those opposite. Mr Deputy Speaker, the LNP stands for victims, and we will make Queensland safer when everyone gets to show Labor the door in 24.
Before calling next speaker,